What happens if you get stopped while filming in public? That's what we're talking about today. Let's go.
It is 2019 in Louisville, Kentucky. A man named Michael Lee Thomas is standing on a public sidewalk recording a police interaction across the street. He is not interfering. He is not yelling. His feet are planted on public ground and his phone is pointed at officers doing their job in plain view. An officer walks over, tells him to stop. Thomas says he has a right to record. He is arrested, charged with obstructing a public way and disorderly conduct. He spends the night in jail. The charges are later dropped. The city settles. But Thomas spent that night behind bars for doing something 3 federal circuit courts had already ruled was constitutionally protected. That is not an anomaly. That is Tuesday. You have probably felt this. You have stood somewhere with your phone up and had that cold, quiet thought, am I allowed to do this? And that uncertainty, that specific feeling of not knowing if you are protected, is exactly what this video is going to answer. Because here is what almost nobody tells you straight. The right to record police in public is real. It is protected under the First Amendment. Federal courts have confirmed it repeatedly, and it will not stop you from getting arrested tonight if you do not know exactly what that right does and does not cover. So here is the question you need to sit with. Do you actually know what to say if an officer tells you to put your phone down right now? Because most people do not. And that gap is exactly what this is about. Let's walk through what actually happens. Not in theory, in the real streets, in real cities, with real people who thought they knew their rights. There is a moment every person recording in public believes they are safe. They are standing back. They are not interfering. They are a witness with a device. And that confidence feels solid. Here is where it starts to crack. What most people believe. If you are on a public sidewalk and a police interaction is happening in front of you, you are legally allowed to record it. Period. Full stop, no question. What is actually true? Yes. And also, it is more complicated than that in ways that can get you arrested before the constitutional question ever gets answered. The First Amendment protects expression. The Supreme Court has never directly ruled that recording police is a First Amendment right. What we have are federal circuit court decisions. The First Circuit ruled in 2011 in Glik v. Cunniffe that recording police performing their duties in public is constitutionally protected. The Ninth Circuit affirmed it. The Seventh Circuit, the 11th. But the Supreme Court has not unified this nationwide with a binding ruling. That means in circuits where the question has not been answered, qualified immunity can protect officers who arrest you for recording, even if you were legally in the right. In 2017, a man named Javier Robles was arrested in Philadelphia for recording a police stop from 20 feet away on a public sidewalk. He had done nothing except hold up his phone. The charges were dismissed, but the arrest was made. The literal sentence you should say if an officer approaches you while you are recording, I am not interfering. I am exercising my First Amendment right to record police in a public space. Am I being detained? Say exactly that. Do not say more. Do not put the phone down unless you are told you are being detained and you choose to comply for your own safety. Now let's talk about what happens the moment an officer tells you to move back. This is where people make their biggest mistake. You feel like moving back means surrendering your right. You hold your ground. You argue the First Amendment out loud. You keep filming. And what officers will often use in that moment is not a recording law. They will use obstruction, disorderly conduct, failure to comply with a lawful order. These are the charges that show up on arrest reports when people are detained for recording, not illegal recording. The workarounds. Under 18 U.S.C. Section 111 and various state equivalents, obstructing or impeding an officer is a separate charge that has nothing to do with whether your recording was lawful. If an officer argues you were impeding their work, even if you were 20 feet away, that charge can survive your First Amendment defense in the short term. You may win in court 6 months later. You will still have been arrested tonight. In 2021, a woman named Oluwatoyin Salau, no, that is a separate case, specifically on obstruction charges while recording police at a distance, suggests checking ACLU case files or Reporters Committee for Freedom of the Press litigation database. Knowing you are right in a courtroom is not the same as knowing how to stay out of a courtroom in the first place. Here is a scenario that almost nobody thinks about until it is too late. You're recording an officer search. The officer does not tell you to stop. Instead, he walks over and asks for your ID. You assume that you do not have to give your name unless you are being detained or suspected of a crime. Here is where it splits in two. 24 states have stop and identify statutes. In those states, if an officer has reasonable suspicion that you are connected, demand you identify yourself, and you are legally required to comply. If you refuse and you are in one of those states, you can be arrested, not for recording, but for refusing to identify yourself while recording. Texas, Nevada, Arizona, Indiana are examples of stop and identify states. California, New York, Massachusetts have no such statute. Same phone, same sidewalk, different legal night, depending entirely on which side of a state line you are standing on. This matters if you are standing in Dallas recording a traffic stop and an officer asks your name, you are in a stop and identify state. Know that before you answer. Now let's go somewhere most people completely forget to think about private property. You are in a shopping center parking lot, a courtyard outside a store, or the lobby of a building that is technically open to the public. The assumption is you are in public and you can record. The reality is, a private property owner has the right to prohibit recording on their premises, even if the premises are open to public entry. A mall is not a public street, and a hospital lobby is not a public sidewalk. If security asks you to stop recording and leave and you refuse, you can be removed and then charged with trespassing. The First Amendment protects you from government restriction of your speech and expression. It does not compel a private business to host your camera. In 2016, a journalist named Jason Padgett was removed from a Houston shopping center while recording a viral incident. He was on private property. The mall had posted no recording policies. He knew his First Amendment rights. Those rights did not apply, and he was trespassed. The exact sentence in that situation was, "I understand this is private property. Am I being asked to leave?" If the answer is yes, leave your right to record police brutality does not begin with getting trespassed from the scene. Now we go deeper into the part that almost nobody talks about. 12 states have what are called two-party or all-party consent laws for audio recording. These wiretapping and eavesdropping statutes predate smartphones and were designed for phone taps, but they have been applied to people recording in public. In the most aggressive readings, you could be charged with illegal eavesdropping for recording a conversation in a public place without consent. Illinois had one of the harshest versions until the Illinois Supreme Court struck down part of it in People v. Clark in 2014, ruling it unconstitutional as applied to recording police. But the law was only partially dismantled, and in other all-party states, the legal picture is still not fully resolved. Maryland, Florida, California, Pennsylvania are examples where the law in your state may matter more than the First Amendment in that moment. This is the gap between the law on paper and the law in practice. Police in all-party states have sometimes used eavesdropping charges against people recording them, not because the charges will hold up, but because being charged is enough to end your evening and cost you money and time. The ACLU has documented this pattern in at least 4 states. Look up your state's consent law right now. Before you need it, search the name of your state plus audio recording consent law. This is a 20-second search that could change what happens to you one night when everything goes wrong. Now for the case that changed something. In 2010, Simon Glik was walking through Boston Common when he saw 3 officers arresting a man he believed was being treated roughly. He pulled out his phone and recorded it openly from a distance on public land. He was arrested, charged under Massachusetts' wiretapping statute, charged with disturbing the peace and aiding in the escape of a prisoner. He fought it. In 2011, the First Circuit Court of Appeals ruled that recording police performing their duties in a public place is a constitutionally protected right under the First Amendment. The court said the right was clearly established and officers should have known. Qualified immunity did not protect them. Glik did not just win his case, he set a precedent used by at least 23 other federal rulings. The arrests that came after him in cities that knew about Glik and still arrested people ended up costing those cities in settlements. Boston paid, Louisville paid, Chicago has paid. And here's the loophole that almost sounds like a joke until you realize it is not. You can legally record in public and live stream in public, but if an officer seizes your phone as evidence and you have not backed your footage up to the cloud, that recording may disappear. The Fourth Amendment requires a warrant to search your phone after Riley v. California, but if your phone is taken before you back up the footage and it is not backing up automatically, the recording can be gone before a lawyer ever touches the case. The loophole is not in the law, it is in the cloud. The moment you start recording something serious, turn on automatic backup, or go live right now, not after, because a recording that does not survive the night does not win the case. Here's the one thing this entire topic comes down to, and I want you to sit with this for a second. The right to record police in public is real and it is protected. Multiple courts have said so, and cities have paid millions to people whose rights were violated, and none of that has stopped the arrests from happening. Because your constitutional right activates in a courtroom, the arrest happens on a sidewalk, and the person who wins a lawsuit 2 years later is not the same person who goes home that night. Knowing your rights is not the same as knowing how to exercise them safely and keep your footage intact. Those are two different skills, and most people only practice one of them. If you are ever stopped while recording in public, do not lower your phone unless you are being physically compelled to. Say, clearly, I am not interfering. I am recording in a public space. Am I being detained? If the answer is yes, stay calm. Do not resist. State clearly that you do not consent to any search of your device and contact a lawyer before you answer any questions. If the answer is no, you are free to go and you go. If you are in a stop and identify state and you are asked for your name, give it. The fight over recording rights is not worth adding a refusal to identify charge to your night. If you are in an all-party consent state record video, and be cautious about how audio gets used in your state's context. Know your state's law before you need it, and the moment you start recording something serious, go live or make sure your footage is backing up automatically. That footage is only useful if it survives. The book that goes deepest on why this gap exists is The Photographer's Right by Burt Craigs. It is written by a practicing attorney, updated through multiple editions, and covers what you can and cannot be stopped from doing in public spaces across the United States. It is short, specific, and the kind of thing you want to have read before you ever need it, not while you are standing on a sidewalk. The link is in the description. Before you leave, I want to ask you something real, not what do you think about this topic, something specific. Have you ever been in a situation where you wanted to record something in public and did not because you were not sure if it was legal? What stopped you? What did you do instead? Tell me in the comments. Because the answer to that question tells you something about how much of your actual rights you have been quietly surrendering without anyone having to take them from you. The law gives you a right. Fear takes it back. If this changed how you see something, there is more. Subscribe.
That's all for this video. For more information, watch these videos.